For nearly 7 years, Texas mother Crystal Mason had the threat of serving a 5-year prison sentence hanging over her head. She was convicted of voter fraud after casting a provisional ballot in the 2016 election while under supervised release from prison. Earlier this year, a Texas appeals court overturned her conviction, and it seemed like it was all behind her. That is, until now. An appeals court is granting the Tarrant County District Attorney requests to take another look. But let me be clear about something. This woman cast what's called a provisional ballot. And let me explain a little bit about what that is precisely. When there is any question about whether you are eligible to vote, we look to a federal law called HAVA. It stands for Help America Vote Act of 2002. And under that law, any U.S. resident should always be able to cast a provisional ballot, even if their registration status is not clear. Now, it does not mean the ballot has to be counted. It's a conditional ballot. It'll only be counted if they're actually eligible. Now, election officials will try to verify voters' identity and eligibility to vote by looking at the voter rolls or verifying signatures. Are they actually registered? Are they voting in the right jurisdiction? Are they supposed to be voting there? Is that a real signature? They may also require additional information from the voter, and they can also require an affidavit like this one in Texas. If they can verify identity, eligibility, they count it. If they can't, they won't. And even if they are counted last. Now, this woman, Crystal, she filed a provisional ballot, but she was also on supervised release for tax evasion in the federal courts. Now, in Texas, you cannot vote while on supervised release because your sentence is not technically over. Now, she says she did not know she was ineligible because of that. Apparently, election officials did, and they didn't count her ballot. Crystal Mason and her attorney, Justin Moore, join me now. Crystal, just going through this and thinking about how this was a provisional ballot that was not ultimately counted, this case appeared over when your sentence was overturned and you were acquitted. How are you feeling now that it's being looked at again?
Overwhelmed. Me and my family is overwhelmed about this matter. And we're just ready for it to be over. This has been going on 8 years now.
This has been, in our conversations in the past, it was a nightmare then. It's a dream you can't seem to wake up from. What are you thinking as you learned that they were going to even look at it again? Have you thought, why me? Why now? Why still?
Definitely. And definitely. First thought was, why me? Why we're still here? I just rejoiced in March for being acquitted. And here I am.
Justin, I want to bring you in here because I'm really curious as to why now. I mean, when Crystal's conviction was overturned, it was ruled that there was not enough evidence to prove that she knew she was ineligible to vote. Is there new evidence? Why is the DA asking the court to look at this again?
Laura, this amounts to a Hail Mary by the Tarrant County DA. I mean, this case has been well briefed. Every lawyer that has seen this case realizes that the briefings have been airtight. The fact that this Tarrant County District Attorney, which is a new district attorney from the original DA that prosecuted Crystal, is trying to ask for a higher court to review the appellate decision that came out in March, it only amounts to political theater ahead of this election. But we do believe that the appellate court that is going to review this case is going to basically affirm and say that we got it right. So we feel really confident going into this next round of briefing.
I mean, the DA, Justin, is arguing that the prior ruling you speak about disregarded evidence that Crystal was aware of being ineligible to vote. What is your response to that?
Look, I mean, on its face, and what's clear in the record shows that Crystal did not know that she was ineligible. And at the very least, that the DA's office did not present enough evidence that was sufficient enough to get over the reasonable doubt standard that all district attorneys have to meet when they're trying to convict somebody. So, the DA's response or the DA's argument, I believe it should fall on deaf ears when it goes back to the appellate court.
Crystal, I mean, you are a mother. You have 3 children. You have a family and a community who is looking to support you. And I wonder how you have been talking to your family about what has been going on, and frankly, how you are keeping yourself sane, knowing that you've had this over your head for going on 8 years.
What I've been doing is it's election time. I'm deputized to register people. I'm to register people to vote. And me and my family, we've been out in the streets, knocking on doors, telling people how important it is to vote. You got to remember the judge, the DA, the prosecutor, they're all elected officials. And this is why we need to get out and vote.
Are you concerned that what has happened to you could happen to others, and that people who may not know about an ineligibility will try to cast a provisional ballot, or just say, you know what, it's not worth it. I don't want to take the risk. I'm not even going to do a provisional just in case. Are you worried that it could have the effect of making people want to stay home?
Definitely. It definitely will have the effect. You got to remember a mother being locked up for illegally voting, for trying to vote. And yeah, that would definitely scare someone away from the polls.
How do you explain it to your family about what you're going through, and how do you keep them strong as you're trying to hold yourself up as well?
Again, like I said, I started the organization Crystal Mason to fight against voter suppression. And this is how we keep ourselves together. We go out and we educate people how important it is to vote. And if you're eligible to vote, we let people know that you need to vote, because it really will make a difference on who we have in the office.
I mean, Justin, a lot of people would take what is happening to them, what has happened to Crystal, and they would look inward only, and they would turn off, and they would want to be distant. Some people would choose that. Crystal has not. She has chosen to have an element of public service in her life. But I do wonder, what is the next step? Give the timeline to me of what happens next. Now that there's going to be the review, do we know when that review is happening? Do we know when a decision will be made? And what more will be asked of you and your client to prove that she is innocent?
So what happens next is the DA's office, they have 30 days to brief their argument and submit it to the Texas Court of Criminal Appeals. And then we have to submit our response shortly thereafter. After that, we're going to get a ruling at some point. Hopefully, it's going to not take as long as it has traditionally taken. And we need the Court of Criminal Appeals to provide a definitive response that shows clearly that Crystal is exonerated from this very frivolous, I guess, war that the DA's office has waged against her and voters that look like her. That's what we need from the Court of Criminal Appeals. If they don't give us a definitive answer, this could very well go all the way up to the U.S. Supreme Court. Hopefully, it doesn't go that far. Hopefully, we can just deal with this now, and we can put this behind Crystal.
An answer for you and for those who are watching to see if they might be next and what can be done about it. Crystal Mason, Justin Moore, thank you both so much.
Thank you.
Thank you,
We'll be right
Laura.
back.